Something significant has just unfolded at the Supreme Court of the United States only moments ago, and it is an outcome that many Americans have been anticipating for decades. For gun rights supporters, it represents the result of years of legal battles across state lines and courtrooms nationwide. For opponents, it reflects the outcome of a long campaign involving substantial financial and legal efforts aimed at preventing exactly this direction. A 6-3 ruling has just been issued through an emergency decision by the Supreme Court. In that majority, 6 justices aligned to produce a result that alters the legal framework surrounding firearms in a direct and unmistakable way. The ruling is being described as clear and decisive, without ambiguous language that would normally require years of interpretation in lower courts. There is often skepticism when major announcements like this circulate, since similar claims have appeared before without matching the actual legal impact. However, this moment is being presented as a real shift, and the focus now turns to what the decision actually establishes, how it functions in practice, and who will be affected immediately versus in later court proceedings. Before going further into the legal implications, it is important to clarify the purpose of this breakdown. The explanation that follows is meant strictly for educational understanding. Supreme Court rulings are complex, and their enforcement depends on interpretation across multiple levels of the judicial system. Anyone needing direct legal guidance must seek a qualified attorney within their state. To understand why this ruling is considered important, it is necessary to look at the long history behind the Second Amendment debate. The disagreement over its meaning has existed since the early foundation of the United States, especially regarding whether it protects individual ownership of firearms or only collective service connected to militias, and how far government authority can extend in limiting access. Throughout much of the 20th century, courts generally treated the Second Amendment as tied to militia participation rather than individual rights. That interpretation allowed wide-ranging regulations at federal, state, and local levels, covering areas such as bans, classifications, and restrictions without major constitutional obstacles. A major turning point came with Heller in 2008. In that case, the Supreme Court recognized that the Second Amendment protects an individual right to possess firearms for self-defense. While this marked a major shift, it also left space for regulations to continue, creating uncertainty that lower courts later interpreted in ways that often upheld restrictions. Later, McDonald in 2010 extended that interpretation to apply against state governments as well. Still, the practical effect remained limited, as lower courts continued to sustain many existing laws through narrow readings of those rulings. Then, Bruen in 2022 introduced a different standard. It required that firearm regulations be justified through historical tradition and rejected the balancing approach that courts had previously used to uphold many restrictions. This change triggered a wave of new legal challenges involving bans, carry rules, and federal firearm regulations, many of which have been working their way through the judicial system since then. Against that background, today's 6-3 emergency ruling adds another layer to that ongoing legal evolution. The size of the majority matters. A 6-3 split indicates a strong alignment among the justices, making it unlikely for lower courts to reinterpret or weaken the ruling's direction without further Supreme Court review. An emergency ruling itself carries additional meaning. These decisions are issued when the court believes that waiting for the full appeals process could result in irreversible harm to constitutional protections. In this context, the court is signaling that the prior ruling under review was likely incorrect, and that allowing it to remain in effect, even temporarily, would have caused immediate and tangible consequences for constitutional rights. This moment carries immediate significance. It does not wait for the standard judicial timeline. It is tied directly to how the Supreme Court is now engaging with lower court handling of Second Amendment cases after Bruen, and after the growing wave of litigation surrounding firearm laws across the country. In practical terms, a 6-3 emergency ruling in the current environment sends a clear message that the court is actively monitoring how lower courts are applying constitutional protections related to firearms. It also reflects dissatisfaction with inconsistent interpretations at the lower level. That signal itself becomes part of the legal environment, shaping how judges, prosecutors, and state officials approach enforcement in ongoing cases. Across the firearms landscape, this affects several key areas where legal battles are already underway. One major area involves assault weapon bans. States, including Illinois, California, Maryland, New Jersey, Connecticut, and Massachusetts, currently maintain laws restricting these firearms. Many of these laws are already under federal court challenge under the Bruen framework. This emergency decision strengthens those challenges by reinforcing the expectation that lower courts must apply the historical tradition standard established in Bruen, and it increases pressure on those courts as they review existing bans. Another area involves restrictions on magazine capacity. High-capacity magazine prohibitions in states such as California, New York, and New Jersey are also under legal review. With this Supreme Court action, arguments against these restrictions gain additional force, particularly under claims that commonly used firearm components cannot be broadly prohibited under the Second Amendment. Each new signal from the Supreme Court reinforcing individual rights strengthens these ongoing cases. A further category concerns carry laws in designated sensitive locations. After Bruen, states including New York and California expanded lists of places where carrying firearms is prohibited. These expansions were widely seen as attempts to maintain regulatory control after prior rulings limited older permitting systems. Those location-based restrictions are now under continued legal challenge, and this decision adds further weight to arguments against them in court. Federal firearm prohibitions are also impacted. Several existing federal restrictions, including those tied to domestic violence restraining orders, certain criminal convictions, and gun-free zone provisions, are currently being challenged under the Bruen standard. The Supreme Court's willingness to issue emergency relief in this area signals that these cases are being closely examined at the highest judicial level. Another ongoing issue involves ghost gun regulations and pistol brace rules issued by the ATF. These regulatory measures are being contested in multiple federal circuits. Each time the Supreme Court reinforces that the Second Amendment must be treated as an active constitutional protection rather than a flexible administrative category, it strengthens arguments against regulatory expansion through agency interpretation. Even with a ruling of this type, the legal reality does not shift instantly across every jurisdiction. States that wish to preserve existing firearm restrictions will respond in several predictable ways. One response is narrowing legislation. States often revise their laws to fit within the boundaries of a Supreme Court decision while still attempting to maintain similar restrictions in practice. After Bruen, for example, states like New York and California adjusted their statutes to preserve regulatory control while formally aligning with the new legal test. A similar pattern is expected again. Another response is delaying enforcement changes. Through injunctions, appeals, and procedural motions, states and local governments often slow the implementation of Supreme Court decisions for as long as possible within the legal system. A third response involves legal interpretation disputes. State attorneys general may argue that specific rulings do not directly apply to their existing statutes, pointing to differences in language or structure between laws. This creates additional litigation that must be resolved over time. On the other side, legal organizations such as the Firearms Policy Coalition, the Second Amendment Foundation, and Gun Owners of America are expected to pursue immediate follow-up challenges. Their role is to convert Supreme Court-level rulings into enforceable outcomes at the state and local level through continued litigation. For individuals affected by current firearm laws, the immediate change is primarily legal positioning. Anyone challenging restrictions on carry rights, magazine capacity limits, or firearm classifications now operates from a stronger constitutional argument than before this decision. Another immediate effect is political pressure. State lawmakers in jurisdictions with strict firearm regulations are now reassessing how their laws will hold up under continued judicial scrutiny, as each new Supreme Court signal increases the legal risk associated with maintaining aggressive restrictions. In certain situations, this can lead to voluntary changes in legislation aimed at avoiding court losses. That, in turn, may produce real and practical relief for firearm owners without each individual needing to bring separate legal action. Another effect is a shift in prosecutorial behavior. Prosecutors who make decisions about firearm-related charges are closely observing the Supreme Court. When a 6-3 ruling reinforces Second Amendment protections, pursuing aggressive charges in legally uncertain areas becomes more risky. In some cases, this directly influences how charging decisions are made. There's also a broader effect on the legal movement itself. Organizations working on Second Amendment litigation, along with attorneys handling these cases and donors funding the efforts, often experience increased momentum after a major Supreme Court decision. More cases are filed, more challenges are initiated, and more requests for injunctions are submitted. Over time, this type of legal momentum builds and expands following a 6-3 ruling of this kind. A clear set of responses has been outlined for situations where firearm restrictions are referenced by law enforcement, neighbors, or government officials. If told that a restriction still applies, the response is to acknowledge awareness of the recent Supreme Court emergency ruling related to Second Amendment rights, and to request clarification of the specific statute being cited before accepting the restriction as fully valid. If informed that nothing has changed, the response recognizes that implementation of legal decisions takes time. It indicates intent to consult a Second Amendment attorney regarding how the ruling applies to the specific situation, while continuing to assert constitutional rights in a lawful and respectful manner. If asked about awareness of the decision, the response confirms that it is being followed closely. It also states the belief that it significantly strengthens constitutional challenges to certain existing restrictions and notes consultation with a firearms attorney regarding personal applicability. The guiding principle is that rights are asserted through legal systems, attorneys, and courts, not through confrontation. The process is grounded in legal knowledge and formal channels, especially in a system that has just demonstrated through a 6-3 decision that constitutional protections are actively enforced. A structured action plan follows for the next 48 hours after the ruling. The first step is contacting a Second Amendment attorney within the state. The specific question is how the Supreme Court decision affects any restrictions currently applied to the individual situation. The second step is reaching out to state-level Second Amendment organizations, such as the Virginia Citizens Defense League, the Illinois State Rifle Association, or the California Rifle and Pistol Association, depending on location. These organizations are actively preparing legal responses following the decision. The third step is maintaining accurate awareness rather than reacting emotionally. Following legal experts and constitutional scholars is emphasized over relying on surface-level news coverage. The real impact of the ruling will develop over the next 6 to 18 months through federal court decisions. The fourth step is documentation. Any current restriction that may be affected should be recorded, including date, location, and nature of the limitation. This information may later become relevant in potential legal challenges. The fifth step is financial and organizational support for legal advocacy groups such as the Firearms Policy Coalition, the Second Amendment Foundation, Gun Owners of America, the National Rifle Association Institute for Legislative Action, and similar organizations. Funding these groups supports continued litigation that transforms Supreme Court rulings into enforceable changes at state and local levels. The overall situation is summarized clearly. A 6-3 emergency decision from the Supreme Court represents a meaningful development. It strengthens ongoing legal challenges involving assault weapon bans, magazine capacity restrictions, carry location limitations, federal firearm regulations, and ATF regulatory authority. However, this is not the final stage. States will respond with new legal strategies. Attorneys will continue litigation. Lower courts will issue further rulings. The ultimate outcome depends on continued legal engagement over time. The most significant benefit goes to those who remain informed, act through proper legal channels, consult qualified attorneys, and support organizations engaged in constitutional litigation. Rights are protected not only through court decisions, but through sustained legal effort and civic engagement within the judicial system. This is a confirmed legal development, but the process is ongoing. Continued attention and lawful action remain essential. End of part. Is this conversation helpful so far?